when I was a candidate attorney. And one of the partners said to me, what were they going to do with me? I said, well, treat me fairly.
Yeah. It was not usual, you will admit, for a black person to become partner in the Big Five in those days, was it?
No, it was a rarity. I never made full partner. I was
As well, even associate partner.
associate partner, yes. It was a rarity, it's true, CJ.
Yeah. But then you took a leap of faith and started your own practice on your own account in 1994.
Yes, I started, and then my long-time friend, although he was from Wits, Mr. Leivre Modisa, joined me. And the firm became known as Mlambert Modisa Attorneys.
You were not given a long time to settle into your practice because you were snapped up by the judiciary in 1997.
That is true. The chase started in 1996, and I resisted it. Felt I was not experienced enough. But Chief Justice Mohammed was very resolute in saying there's a new constitutional dispensation that requires people to come and support the new constitutional project. So in 1997, they eventually ensnared me into the judiciary.
Yeah, that's a call that was made to a number of us, which was impossible to resist. You were a judge in the labor court for, was it 3 years? 1997 to 1999. And then moved to the High Court in 2000.
I started acting in the High Court in 1999. I was actually surprised when Judge President Elof called me directly to invite me. So I was acting, and then 2000, I think that's when I was appointed permanently, if I'm not mistaken. Yeah.
Mm-hmm. Your questionnaire does not make that clear. So you were at the High Court until 2005?
That's correct, but I started acting in the SCA in 2003, I think, and never came back to the High Court.
When were you appointed to the SCA?
In 2005, I think.
In 5. But it took a bit of time for you to report in Bloemfontein for some reason. When did you report for duty?
Report to, sorry, CJ?
When did you, I'm saying that I remember that you were appointed permanently in 2005.
Yes.
But you did not immediately report for duty there. It took you a bit of time while you were winding up your affairs in the labor court or in the High Court?
Oh, yes, I remember. Thanks for reminding me, CJ. Yes. I was allowed to spend, I think, probably 9 or 10 months in the labor court to finalize, labor appeal court, that is, to finalize work. That was before I took up the appointment in the Supreme Court of Appeal.
Then you did report for duty and stayed in that court until 2010.
I did, CJ. You remember that's where I first met you.
Yes. And you were there until 2010 when you were called back to the labor courts.
That is correct. In 2010, the acting JP at the time, JP Wegley, paid me a visit and asked me to stand. I thought it was uncalled for because he was the one who was supposed to take over, but he was the one inviting me. I resisted, but I eventually, when the whiff of leadership hit me, I decided, well, that was the way to go, and I accepted.
Yeah. And you would not stay there for a long time. Another call came for you to make your way back to the High Court was it in 2012?
That is correct, CJ. I got a number of nudgings from a number of angles to avail myself. I had not intended to, because I was already ahead of court, but I eventually acceded, and here I am, JP Gauteng.
Yeah. And here you are today. You have been in leadership for a long time in this institution, JP Mlambo.
That is correct, CJ. I started in 2010 as head of court.
And I know, and if some of us know, just how much you have done in that time. Would you just highlight for us some of the key things you have done, you have initiated and implemented to improve the lot of the judiciary and our people?
Thank you, CJ. And I think I was remiss. I should have greeted all the commissioners properly, the president of the SCA, the minister, JP Hendricks, all the commissioners. Please forgive me for not greeting you properly. CJ, when I took over as JP of the Labour Court, there was a raging debate in that court whether it should, the LAC should become a chamber of the SCA. I'm sure you remember that debate at the time. And there were two schools of thought in the LAC about whether they should be a chamber or whether they should stay as an appellate court in their own right, and whether their appeals should still go to the SCA or should go to the Constitutional Court. But I encourage that discussion to continue, and I think we ended up agreeing that the LAC was better placed standing as an appellate court in its own right in labor matters. But the focus of my attention when I took over in the Labour Court was, it was in a dysfunctional state, that court, to put it mildly, in the sense that files were being lost routinely. I think the issue of the allocation of trial dates, review application dates, was still based very manually. I remember the 5 registrars who each held a diary. And the routine loss of files, as well as the duplication of case numbers, said to me, someone needed to reform the whole case flow system of the court. And I remember asking for extra hands, and I was granted an opportunity to employ 3 more legal interns to go through all the court files that had been lodged, because some of them were files that had been lodged but that had not been processed, but they remain active or live. And I remember at the end of it, we had identified a number of files. Those that had not been actioned in more than 3 years, we archived immediately. And those that were this side of 3 years, we wrote letters to the parties to say they needed to tell us what they wanted to do. If they didn't want to do anything, we would archive those files. And that freed a lot of space for new cases to be lodged in. I think in 6 months, I want to believe I had turned around the functioning of the Labour Court. There was no problem with the Labour Appeal Court, but just as a conduit to the Labour Appeal Court from the Labour Court, a number of cases that should have gone there earlier were not going there earlier. So the cleanup that I did enabled matters to start going to the Labour Court appropriately. I think the other thing that I did is to reignite the relationship between the leadership of that court and NEDLAC. NEDLAC plays an important role in labor law in South Africa, especially the functioning of that court. This commission knows there's NEDLAC presence, even though not at voting stage, in this court when labor court candidates are interviewed. So I left in the happy space that a number of key amendments to the Labour Relations Act would now be in good hands at NEDLAC through the leadership of the Labour Court. But then I had to leave and go to the High Court. When I was at the High Court, when I stood for the High Court, I identified a number of fault lines. One of them was judges in the agent court, in the High Court in Gauteng, regarded that court as hell. Only one judge did the agent court in a week, that is day and night and weekends. And I said, that's impossible for one person to do it. And I introduced a two-judge system. And the rest is history as how judges are able to manage the load of that role. But I also identified that there was a problem with part-head trial dates. The norm was a part-head civil trial only came back after 3 years. And that was inimical to proper access to justice. And I introduced a system where I enabled judges that whenever they are sitting in a civil trial that they realize was going to become part-head, before that matter ended in that first sitting, they should source dates when they could be available in the following term. And I would factor that in the roster that I would issue for the next term to make sure that there's continuity, right, with the trials. That was the other thing. And the other thing was to reform the opposed motion litigation in Johannesburg. In Pretoria, the opposed motion was reformed in such a way that judges received their files 2 weeks before the matters were to be heard. And that enabled them time to read and prepare so that they didn't have to rely on counsel to take them through their papers. And Johannesburg had been resistant to that way of doing things. I know it was a mammoth battle to convince the Joburg Bar in particular. Judges understood the benefits of the new system, but I succeeded in making sure that the litigation system in the opposed motions is the same in Johannesburg and in Pretoria. What I also eliminated, Chief Justice and Commissioners, was the red card system. The red card system applied to matters in the civil trial role, that if you'd had no allocation by Friday, you then had to go back and start afresh in getting a new date. And I felt that was inimical to access to justice. And I ended it and cemented the issue of appropriate roll call by the DJPs, as well as ensuring that the civil trial role judges are increased in such a way that they are able to deal with each week's load that comes. And that got rid of the red card system that applied. It applied a lot more in Johannesburg than in Pretoria, right? Those are the initial things that I did, CJ, but there are a number of other things. I was appointed by Chief Justice Ngobo to head the Judiciary IT Committee simply because I was the only head of court who came to meetings with a laptop. And I remember one meeting, JP Ngwepe happened to sit in my seat in front of the laptop, and the JP Ngobo remarked that there was something wrong there. The laptop and JP Ngwepe. I won't discuss what he said was wrong, but he appointed me to head that committee. I continue to head it, and in that position, CJ, we've been able, as that committee, to introduce case lines to the South African judiciary. It's a revolutionary way of electronic case management and case filing. It came in very handy during COVID. We've gone further. We've now cemented the implementation of Court Online, which is the proper e-filing and litigation system, where files will then be bundled onto case lines, which is an evidence management platform. So those are some of the things I've done, CJ. I've introduced committees. I mean, at my instance, when I saw the rise in fraudulent court orders, I persuaded Chief Justice Mukweng to establish the Court Integrity Committee to track and monitor the incidents of fraudulent court orders that were being used, and to establish a relationship with the DPCI to regard those offenses, court-related offenses of that nature, as priority crimes, and to fast-track their prosecution. Unfortunately, we've laid many criminal charges against the people who use fraudulent court orders, but DPCI still has to come to the party because those matters are routinely withdrawn. So there are a number of other things, CJ, unless you want me to mention them, but can I stop there? I can deal with others that commissioners may want to raise.
Indeed, there are many others. You play quite a number of roles in the heads of court cluster. And you've only mentioned just one of the things you do there, but I think that's enough. Court modernization and digitization and the work you do as JT, I think is a big enough undertaking. So point is taken, JP Mlambo. While you were doing all these things within the judiciary, you were doing other significant things outside the judiciary, quite a number of other things, and I highlight only two. Your role in the global executive, that's a role you've since assumed. Your role in the IARMJ, of which you are now executive council member, heading as chairperson its Africa chapter. Yes. What is the IARMJ? It's quite a mouthful.
It is the International Association of Refugee and Migration Judges. It is, incidentally, it was launched here in South Africa in I think it was 1989. No, not 1989, I think 1999, if I'm not mistaken. It is an association of judges internationally who have an interest in the development of refugee and immigration law. Because of the migration patterns that sees South Africa being a favorite destination in this continent, and not only drawing continental Africans, but also people from other continents. When I became JP Ngwepe encouraged me to join that association. And our interest as an association is that we take no sides, because we are composed of 4 chapters globally. It's the African chapter, of which I'm the president. And then you have the European chapter, which has seen a lot of developments around the international instruments. And then the Americas chapter, as well as the Asia Pacific chapter. All of these chapters bring different dynamics onto the table about the development of refugee law. So the main focus of the association is to run professional development programs, especially continentally and globally when we meet every 2 years, to keep each other updated of groundbreaking judgments in whatever continent they are, or even in this continent. And I can tell you, CJ, a lot of the jurisprudence that's generated from South Africa plays a central role in the jurisprudence discussions of these associations when we meet during the world conferences. So ours is to develop ourselves as judges to understand what we are dealing with. We have the UNHCR as a very big partner in this regard, which has the sources of case law and other international instruments that apply to this field, which is the go-to place when you are looking for any document. There are experts around the world, even South Africa has experts, that also take part in the professional development engagements that we have. I've been successful in organizing a very big conference of the Africa chapter in Arusha in 2022, And then the last one was last year in Sharm el-Sheikh, Egypt, where we bring judges from the whole of Africa coming to look at what's happening, to share their country dynamic experiences, as well as to learn about what's happening and how to deal with refugee and immigration law. And the interesting part, CJ, is, when you meet judges from the civil law jurisdictions, you get to understand how they do work, how the executive remains a very dominant player in the affairs of the judiciary in those jurisdictions. But we meet, we mingle, we learn. So that's the major focus area of the Refugee Law Association, Chief Justice.
You did not mention the work you did at the Legal Aid Board, where you were involved for, was it 17 years, between 2002 and 2019?
Yeah, CJ, yes, I was, that's another role where I was ensnared by Justice Nafsa and the late Justice Charles Carson, Chief Justice Charles Carson. They invited me as if it was going to be a morning meeting, but then I found myself being a board member. Hardly had I settled down, I found myself as chairperson, but I didn't look back. That was an organization that needed serious attention. And I think that's the entity that gave me a different perspective as a judge to see how things actually happen operationally when you are in charge of an organization that has a budget that side of 2 billion, and how you see how that budget, you track its monitoring and how you account to the Attorney General for how you've used the money. I've been to the Portfolio Committee and to SCOPA as chairperson of Legal Aid a number of times to come and deal with issues that were being raised around Legal Aid. And at Legal Aid South Africa, two very important developments happened under my watch. The first one was to reduce and minimize the judicare system, because we viewed that as money going down the drain. We could not see the results of the cases that were being handled on judicare. And we introduced the salaried lawyer model to say, if you tighten performance management of these lawyers that were getting a salary, and you control the caseloads they have and the courts that they attend to, you could get a lot of work done. That is, you can get little money, go very far, as opposed to the judicare system, which had become very expensive. So that was the one thing. But the other thing, hand in hand with the salaried lawyer model, was we introduced the Justice Center model. The Justice Center model was to establish a center in particular areas where you have paralegals, lawyers, and what we call high court units, although the high court units came later, where you have advocates or senior attorneys who service only high courts, whereas the lawyers service magistrates' courts. So the Justice Center model, CJ, has become the preferred model of providing legal services to the indigent internationally. During my term as chair of Legal Aid, we hosted not less than 10 international delegations coming to Legal Aid, coming to learn about what we were doing and how we were doing it and how we could assist. I also traveled extensively. I remember going to India to train legal aid personnel from, I forget this country now, but we couldn't go there because of the political influx. I'll remember the country now, where we were training them. But that was not the only country where we went. We assisted actively. Botswana is one example, where we assisted them come up with their own Legal Aid Act, right? Even though the Legal Aid Act of Botswana emphasizes more civil legal aid than criminal legal aid, they still use the Prodeo system, but it's a very efficiently run Prodeo system that they run in Botswana. So I ensured that the Justice Center model gets mileage throughout, And as long as we have the will of government, fortunately in South Africa, the Department of Justice is a very willing department under which the Legal Aid South Africa resorts to provide the funding and to support the funding of that entity. I remember when budget cuts were first introduced, the impact was going to be terrible because that would mean less lawyers. And when I went to meet Minister Hadebe at the time, who I reported to say, Minister, we are going to close these. We're not longer going to service these courts because we don't have the personnel, right? And then he said, no, you must tell that to the Minister of Finance. And when Minister Manuel heard the story, they didn't introduce budget cuts for Legal Aid South Africa for that reason. So, but I think the other important thing is to put Legal Aid South Africa on the international stage, Chief Justice. I attended a number of sessions in Vienna, right, of the UNODC. And two of those were seriously involved, where I was appointed to chair two expert groups. I remember the first one, that 43 experts from 43 countries to settle the UN principles and guidelines on access to criminal justice internationally. And it was a 5-day project and very successful. The other one was settling what is called the Mandela Rules, which has to do with the treatment of prisoners. That was a 5-day process in Cape Town, but it had taken the previous 4 years to come to that stage because they had not reached consensus. Even there were about 46 countries or 44 countries that were represented. I was also appointed to chair that one and negotiate until they actually came up with the document that we have today called the Mandela Rules. So, but the upshot of it is Legal Aid South Africa became a big player in criminal access to justice internationally, because that's where it is located in Vienna in terms of the UN arrangements. Let me stop there, CJ. There's a lot to say.
And there are, of course, a few other bodies, similar bodies in which you are involved. But you've given us quite enough in that regard. Back to your work as a judge, as head of court, you sit in PEC and NEC. Would you just tell us a bit about these bodies, what they do, and your role there?
Thank you, Chief Justice. The PEC is a provincial structure that brings on stakeholders in the justice system of that province. So you had the provincial leadership coming, infrastructure, the police, prosecution, legal aid, you name them, they're all there. Even the magistracy, they come there. It is a structure where we look at the bottlenecks and the problems that are bedeviling the proper access to justice in particular courts or in the province in general. And it is a very useful structure to have, Chief Justice, because that way we are able to make the provincial leadership of structures that may be causing the bottlenecks to come and account why they're not doing what they're supposed to do. The biggest challenge that we've had over the years was the infrastructure-related challenges that come to the PEC, where you'd have no attendance from officials from the Department of Public Works. That has been addressed in a sense, because JPs are now reporting that DPW officials are now attending that, and they are now accounting. Because it's one thing to attend a meeting, it's another to ensure that projects have traction. And that's the biggest issue. And through your support, Chief Justice, when you were appointed, you took over from Chief Justice Zondo, who had initiated a ministerial committee that actually addresses infrastructure-related challenges in the judiciary nationally. So the PEC plays that role, case flow in particular, as I said, and then other issues. And then if issues can't be resolved at PEC level, they get escalated to the NEEC, which you chair, Chief Justice. So that's where the national leadership of these key entities must come and account why these projects are not moving. Despite our best efforts, Chief Justice, some of these projects still don't move. I mean, the Pretoria Magistrates Court was banned more than 10 years ago. It is still being reconstructed. It took, I think that project was dormant for about 6 or 7 years when nothing was happening. And it was through the efforts of Chief Justice Mogoeng to actually hold a meeting at Silverton where he went on national TV to lambast what the DPW was not doing to delay projects like that. I mean, the other court that bent down was the Polokwane one. It also took a long time, but that has now been finalized. So those are the type of things, because infrastructure-related challenges, Chief Justice, have an impact on how the judiciary works. There are horror stories that you hear of magistrates that won't sit when they don't have water. And you find that the simple reason is that there's been no payment, right? Or you find magistrates that don't sit when it's the rainy season because the roofs leak. So these are the types of issues that we deal with at PEC and at NEEC level.
Yeah. You were part of the high-level delegation that recently and very successfully negotiated the judiciary's full independence with the executive, not so?
That is correct, CJ.
And made a powerful presentation on behalf of the institution in that gathering.
Thank you, CJ. I thank you, CJ, because you have an inclusive and team leadership style, and you included me in that team and you allocated me that role.
I won't say no to the compliment. Thank you, JP. I want to ask you about your core function as a judge, which is to sit in court and listen to cases and, importantly, produce judgments. I think that the body of judgments you have produced, and you count about 176, I think it speaks for itself. I will leave it to other commissioners if they so wish to deal with that later during the interview. But suffice it to say, you have written judgments on the widest spectrum of legal issues, as I see.
That is correct, CJ. I mean, it's one of the issues you have taken up and ensured that it is addressed. The president of the SCA is sitting next to you. She will testify to this. As heads of courts, we must sit in these matters. But because of the demands of our work as heads of courts, we don't sit as much as we would like to. One reason is the demands of our work, as well as the capacitation of our support structures. If I've got to sit in court and rely on researchers, in Pretoria there's 6 researchers. In fact, there's 5 now because we were involved in a fight to fill in the other position. All the other 44 judges of the division rely on those 6 researchers. And if I have to come, I also have to rely on that. So it's a very difficult situation to find oneself in, but we still try. We try our best to do that, yes, to sit in cases.
All right. We are going to give you a bit of time, no longer than 30 minutes, to tell us what your understanding is about the role of a Deputy Chief Justice and how you intend to fulfill that role if you are appointed.
Thank you very much, Chief Justice. And thank you very much for this opportunity to deal with my understanding of the role of the Deputy Chief Justice. And I think I also thank the Commission for interviewing me to assist the Commission in assisting the President appoint the next Deputy Chief Justice. I say up front that it would be an honor for me to serve as the next Deputy Chief Justice. My view is the Deputy Chief Justice is a very important position in supporting the Chief Justice and the work of the Constitutional Court in particular, in carrying out the constitutional objective of a just and socially transformed South Africa. I emphasize that the judiciary, but more the Constitutional Court, has the function allocated to it by the Constitution to be the arbiter of disputes that relate to the exercise of public power. And that is a very mammoth task of the court, the Constitutional Court in particular. And I think the Deputy Chief Justice, being next to the Chief Justice, is key to the success of this constitutional project of socially transforming South Africa. My view is, and this is based on myself, I regard myself as an activist judge. I know a lot of people have quibbled, what do you mean? I can still say I'm an activist judge because I understand my role in terms of the Constitution, which is to use the law to ensure that South African society is adequately transformed based on what has happened in the past apartheid years. And in doing so, Chief Justice, one has to have a very well-developed worldview in the judiciary. I am one South African judge who has networked with judges on this continent, senior judges, in a number of aspects. One of them I've dealt with as president of the Africa chapter. That has given me the opportunity to interact with the leadership of the judiciary, of the African Court itself, of the East African Court of Justice, of some of the jurisdictions like the Tanzanian Chief Justice and the senior members of that court. I have had occasion to meet with judges from Zambia, from Ghana, from Liberia, from Kenya. I have had that opportunity to interact with judiciary members in this continent to understand what they do. And I want to believe that this well-developed view of the African judiciary landscape will stand me in good stead, should I have the honor of being appointed, to bring that experience to bear in the deliberations that happen as we continue with the constitutional project of interpreting our Constitution, in ensuring that the Bill of Rights, the Constitution, becomes a reality in South Africa. Having said that, Chief Justice, my view is the Deputy Chief Justice must possess strong intellectual leadership skills to support and advance the constitutional jurisprudence development of the Constitutional Court. The Deputy Chief Justice, as supporting the Chief Justice, must have a very well-developed operational as well as a systems and administrative sense to ensure that the operations of the Constitutional Court and of the general judiciary goes according to plan and achieves its objectives and is efficient, right? That meeting that we had with the President recently, Chief Justice, which you led, the President has confirmed to South Africa that the independence that the judiciary has been calling for is going to become reality. That will bring more obligations and responsibilities to the judiciary, I mean, taking account of the infrastructure portfolio itself, it comes with a budget, it comes with staff. You need to have an OCJ that is well able to deal with that new responsibility and ensure that it finishes and starts new projects that we've been calling for and complaining about effectively. So the Deputy Chief Justice next to the Chief Justice must have these skills to guide these processes. I mean, President of the SCA sits there, has been doing a very good job chairing the Judicial Operations Committee, because that's the committee that's going to take charge of the operational footprint of the OCJ. And the DCJ supporting the Chief Justice will play a very important role in guiding how we deal with these additional budgets. As I said, at Legal Aid South Africa, I dealt with a budget of more than 2 billion. I'm subject to correction, but I want to think that the budget I dealt with as chair of Legal Aid South Africa, the board, is more than what the current budget of the OCJ is. But that budget of the OCJ will increase, and that comes with serious responsibilities. CJ, I say it without any fear of contradiction that the judiciary is society's true intellectual real estate. It is the arm of state that must ensure the continued confidence of society in our constitution and the rule of law. And the Chief Justice, as the leader of the judiciary, supported by the Deputy Chief Justice, will execute this objective very ably. I want to also mention a number of focus areas that I think are important in what the Deputy Chief Justice will be responsible for. And I've separated this into 4 focus areas. And these focus areas are expanding on what I mean by the Deputy Chief Justice supporting the Chief Justice. And this first focus area is supporting the Chief Justice's vision. The next focus area will be supporting an efficient constitutional court and judiciary at large. The next focus area will be what I term rule of law threats, which I think as a judiciary we need to be mindful of. And when we engage with the executive, we mention this because the executive and the legislature constitutionally must support the work of the judiciary. And where needs be, they must defend the judiciary where it comes under unnecessary and unwarranted attack. The last focus area deals with my own leadership track record, which we've dealt with a bit now. So I mentioned these focus areas, Chief Justice, simply to buttress the importance of the role of the Deputy Chief Justice. Chief Justice, you've hit the ground running as the current Chief Justice. Your vision is very clear, the independence of the judiciary. And hardly a year in office, the executive has yielded. We've been fighting this battle for the last 14, 15 years. But now it's going to become reality that we will also be institutionally independent. And as I say, the Deputy Chief Justice must support your role in ensuring that when this institutional independence becomes reality, we as a judiciary ensure that we use it to the betterment of South African society. Chief Justice, you are aware, and everyone else in this room is aware, that now and then, and on a rising, growing level, there are people who actually are suggesting that we don't need a constitution. There are people who are raising concerns about whether the constitution has delivered or whether a new dispensation is required. Those are important discussions, Chief Justice. I sit here as head of court, well aware that yes, in certain parts of society, the Constitution has not become reality. We still find pockets of abject poverty. We still find pockets of people who do not know the Constitution, who do not know that they can effectively use the courts to their existence. But you ask yourself, how can they use the courts if they don't have the funds to access courts? So that's the reality of South Africa. And as Deputy Chief Justice, should I have that honor, I have been very active in giving public speeches. I think in addition to speaking through our judgments as the judiciary, we must also engage with civil society to face criticism and deal with the issues that are raised about whether the judiciary has failed in ensuring that the Constitution becomes reality. So, on judicial independence, coming with the single judiciary concept, Chief Justice, that is bringing the magistrates on board, I think the Deputy Chief Justice will play a key role in assisting this vision to go in the right direction. The current document that we have in place that puts our position as a judiciary about what institutional independence we want leaves a remedial role for the executive, that is the Minister of Justice, in regarding the magistracy. I think as a judiciary, we still need to grapple with that and understand what are the parameters of the continued role of the executive in the affairs of the magistracy. So the Deputy Chief Justice will play a key role in assisting that. The other part of your vision, Chief Justice, is capacitation of the judiciary. I mentioned researchers, but more so, there's an issue about judicial capacitation. Almost all courts require new judicial posts. The work of the judiciary has increased. Everyone knows that. But the capacity or the establishments that deal with this work has not been increased. Some of the things I've done in Gauteng is to go to the bar and to the legal profession to ask for senior members to avail themselves to come and do pro bono work, that is unpaid work, because it just is impossible to deal with the demands of the work that comes through with the current establishment. So I believe the Deputy Chief Justice will play a key role in supporting you, Chief Justice, in that vision of appropriate capacitation of the judiciary, not only from a judicial post point of view, but also from a support point of view. Appropriate researchers. I mean, the High Court of 43 people can't be meaningful in doing its work if it only has 6 researchers. I think that has to be looked at. That has to be beefed up to ensure that the constitutional project becomes a success, because judges well supported and able will be able to make sure that there's timeous hearing of matters and timeous handing down of judgments. Chief Justice, the Deputy Chief Justice is also key in supporting your overall vision of an overall transformation of the judiciary. You've been very meticulous in ensuring that we don't willy-nilly adopt a sexual harassment policy. That sexual harassment document is going through a number of phases because it goes hand in hand in terms of transformation and the proper understanding of our dynamics as we work in the judiciary. So, Chief Justice, a Deputy Chief Justice will assist your vision in driving overall transformation, as well as the emphasis on advancing women, right? So, the Deputy Chief Justice will have to understand that this is a key constitutional injunction, transformation in the judiciary. I have committed myself to the transformation of the bench. And if one looks at my track record as the people I've invited to the bench, the people who've been appointed under my watch, I want to believe that if I have the honor of being appointed, I will continue with that project of assisting the Chief Justice in this vision, Chief Justice. The other aspect that's part of your vision, Chief Justice, that needs to be supported is appropriate and adequate remuneration of the judiciary. Correctly so, you gave me the responsibility to address the President and members of the executive on this. The judiciary, as we speak today, the salaries of judges have regressed by not less than 34%. And that is the only part of the groupings dealt with by the Commission that has lagged so far behind. And the perils of this, Chief Justice, is if the judiciary is not appropriately remunerated, we don't come to the bench for money. That is correct. But we have lives to live. Some of us still educate children. We've got debt to service. It is implicit and important that the judiciary is appropriately remunerated. And Chief Justice, that's one of your vision issues, that the Deputy Chief Justice will assist you. But the other one, which we've dealt with briefly, is continued modernization of the judiciary, Chief Justice. I've been fortunate that I've been central to the modernization of the judiciary in South Africa. Yesterday, I was talking to one of the OCJ officials about the Microsoft Copilot, about what this is an AI tool. And we have it, but I know that judges don't know it, don't know how to use what Copilot is. But perhaps my inquiring mind, and being the chair of the JAID committee, the IT committee, gives me these opportunities to think about and discover new tools of how we can work. So it is one of your vision issues, Chief Justice, that we must pursue modernization as far as possible. It was yourself, CJ, when you sent us the UNESCO document on AI. And you gave us a challenge to say, come with policies and guidelines about what the South African judiciary can do on the AI front. So on the court online case lines rollout, were I to be appointed Chief Justice, I will continue, with your permission, of course, to ensure the rollout of the case lines and court online. As we speak, 7 courts are live. They are now using that platform. We still have others. I want to believe that by the end of the year, the remaining courts will have gone live as well. I'm going to act in the Concord from 1 August. And I've told you, CJ, that I refuse to go back to paper. I'm going to do my appeals online. And I hope, Chief Justice, with your permission, I'll be able to entice other members of the Constitutional Court to start doing their work online. I mention this for this simple reason, Chief Justice. I've done research about what other appellate courts have done in terms of ensuring efficiencies in their programs. Nigeria, the state of Lagos judiciary, Brazil, India, US, Germany, Canada, and Kenya, and Ghana, to make a few, have introduced electronic case management systems in their processes, and they have reported serious efficiencies in their operations. So, Chief Justice, I will continue in supporting your vision. That's the first focal point. The other focal point that I want to talk about as to the role and my understanding of what the Chief Justice, the Deputy Chief Justice should do, is to support an efficient constitutional court and the judiciary at large, efficient in its operations, Chief Justice. The delays that one sees reported on matters get filed on particular days, but it takes so many years for those matters to be heard. And once they are heard, the delays that come with judgments not being handed on time. I think the Deputy Chief Justice will play a key role in engaging the heads of courts with yourself, Chief Justice, to understand the true reasons. One of them is support, I've mentioned it, but there are others. But focusing on the Constitutional Court itself, Chief Justice, I've done a research about what other appellate courts do to control their docket and to ensure they don't have backlogs. South Africa is the only court so far that has an 11-member, or I'll say 8-member bench that must hear and decide all cases. The international law is smaller panels. And I'm happy that this discussion has already started, led by yourself, of course, Chief Justice. But if you take India, India receives more than 80,000 petitions per year. It is impossible for that judiciary to deal with that type of caseload. But they've introduced electronic management, but they use smaller panels to deal with how they deal with applications for leave to appeal and hearings themselves. And throughout my research, the key considerations in the matters that deserve to be heard by the appellate courts, Chief Justice, are matters of a constitutional nature, matters of national importance, resolving conflicting judiciary pronouncements, just to name a few. Now, our Constitutional Court, every justice must look at the new apps, that is the petitions. And this is an incidence of the increase in its jurisdiction. Kenya, the Kenya Supreme Court is composed of 13 justices, but that court deals with its hearings in 5-member panels. And that enables it to push more cases through its system. The German Constitutional Court, it has 2 chambers of 8 justices each, and only 6 of those can participate in hearings. But in terms of petitions, Chief Justice, 3 of those 8 justices deal with those petitions. And once they've disposed of them, they don't have to capture the attention of the other justices. I mean, the US Supreme Court has what we call the rule of 4. It's an internal rule that that court uses to deal with new petitions. It receives more than 7,000 petitions per year, but it hears not more than 100 per year. And the way it does it is, anyone who wants to send a matter to that court has to apply for a writ of certiorari. That's what they call it. And only 4 justices are required to vote for a certiorari certification to be issued. If there's 1 or 2 that vote for it, but the others are not interested, that's the end of that matter. So I'm just buttressing the need for new thinking about how the Constitutional Court can do its work and deal with the backlog that it has of new apps. I don't like it to see that some judgments of the Constitutional Court are reported as taking 9 months, 8 months or so. It's not good. So, as Deputy Chief Justice, if I have the honor of being appointed, I will ensure that there is robust discussion at ensuring that a new way of how that court deals with its work is found. One other way that I thought I would suggest, CJ, and I mention it here, is the Supreme Court of Appeal. If you look at all the reports, it's a well-oiled machine. It functions perfectly. It has no backlog. That court, through the Superior Courts Act, is able to grant leave where the High Court has said no, and remit that matter back to the full court to deal with that appeal. The Constitutional Court doesn't do that. You find matters where the High Court has refused leave. It's gone to the SCA has refused leave, has not had the matter, refused leave. Goes to the Court. The Constitutional Court finds that there may be an arguable point and grants leave and hears that matter. Why is it, especially where the matter involves the common law, why is it that the Constitutional Court should not be enabled to grant leave and remit to the SCA? Because in many judgments, the SCA, the Concord has said it will benefit from the reasoning of the SCA, especially in matters that deal with the development of the common law. So it's an idea I have. I think it's one of the aspects that can relieve the Constitutional Court of the load that it's carrying in terms of all the cases that it has to hear. So that's as far as the workload processing of the Constitutional Court is concerned. And as I say, my operational sense, which I've gained as chair of Legal Aid South Africa and visiting justice centers, engaging with stakeholders and understanding what critical issues are. I mean, when I visited Australia years ago, I discovered the High Court unit model. Previously, Legal Aid South Africa didn't have High Court units, that is, units that serve High Courts. And I came back and we discussed it to say it makes sense for each province to have a High Court unit where you have senior attorneys and senior advocates who do the work of the High Court. So, CJ, I'm saying this operational sense that I've gained will stand me in good hands in terms of, in good stead, in terms of assisting the CC, that is the Constitutional Court, as well as the judiciary in terms of dealing with their workloads. I mean, I've mentioned all the time that the turnaround times of criminal trials in the regional court leaves a lot to be desired. You can check any awaiting trial detainee report, you'll see that there are cases that still take 9 years, 8 years to be finalized. And these are people who are presumed innocent. So we need to put our thinking caps on, CJ, and deal with that. I'm not sure in terms of time where I am. I still have 2 focus areas.
1 minute left, as a matter of fact.
Chief Justice, I'm sorry about that, but one other issue...
You can round off, JP.
Thank you. One other issue that I thought I will raise is, Chief Justice, there are certain threats that I see are threatening our rule of law arrangements. One of them was mentioned by the acting DCJ on the 19th during the dinner where you're welcoming our international delegates to the 30-year celebrations. That is where powerful people criticize the courts with unsubstantiated cases. Powerful people who criticize the courts, who impute corruption and other negative imputations on the judiciary, are a threat to our rule of law. South African society is a gullible society. I'm not on social media, but I'm told about what gets said there about the judiciary. I think the Deputy Chief Justice should take up the mantle of supporting yourself, CJ, in engaging the legal professions as well as civil society formations in discussing and making them aware that this type of wanton, unfounded criticism of the judiciary is a problem. That's the one aspect. But the other aspect, which I think is a threat to the rule of law, Chief Justice, is there's a recent trend that has come up now where legal professionals come to court wanting to pick fights with judges. Not only does it end there, you've got a trend now of legal professionals encouraging their clients to lay judicial misconduct complaints against judges who rule against them. The JSC has a number of those. This amounts to intimidation of judges. It can't be allowed. It can't be that if I sit in a matter, I've got to check if I rule this way, will there be a complaint? If I rule this way, there'll be a complaint. I think this is an important issue that needs to be confronted and dealt with. So it is the weaponizing of the complaints mechanism against judges, and it is a threat to judicial independence, Chief Justice. A strong and independent judiciary is a prerequisite for our constitutional project. And there should be an independent and ethical legal profession as well, Chief Justice. I think another trend that I'll just mention is the growing trend of corruption in courts. And I don't want to be understood to be saying judges are corrupt. Chief Justice, you had to go to Mthatha because of media reports that said there was corruption happening in that court. It's not only in that court. I'm sure you remember a week or two afterwards, there was a raid by members of the DPCI in my court in Pretoria. I was fully aware that raid was imminent because I've been involved as head of court in discussions with the leadership of the courts as well as the legal professional bodies. Because, Chief Justice, there are members of the legal profession who are involved in this corruption, who benefit. And every time when you get these reports, you ask, I'm looking for names, I'm looking for affidavits. No, we can't give you that. We are scared. Scared of what? But that will undermine the rule of law, Chief Justice, if corruption continues. So I think it's a project that I think the DCJ should undertake to assist the Chief Justice. Because I don't have time, I wanted to talk about my proven track record as a leader, but I just need to leave this thought. Chief Justice, I have strong institutional experience at leadership level. I have experience in dealing with national budgets, as I said. I have been fortunate to be assigned leadership roles in the judiciary. I chair the Infrastructure Committee, JADE. I sit in the Remuneration Committee of the judiciary. I think my leadership style, Chief Justice, is one of inclusivity, team leading, and enabling. Were I to be appointed or recommended as Deputy Chief Justice, I will continue in that leadership philosophy because I think it builds onto yours as well, Chief Justice. You have that way of leading people, that as leaders, we need to work together. I'm one person who recognizes that we are not equally endowed. There are judges who are smarter than me. My role as a leader is to get them to me so that we work for the common good of the judiciary, Chief Justice. One thought that I want to leave is, as a young member of the judiciary in 2012, I was invited to a judiciary leadership retreat by Chief Justice Mogoeng. That retreat came with 3 very important key issues that we implemented. One of them was judicial case management. You remember, Chief Justice, that in 2011, after the judges' conference, one of the resolutions was judicial case management. But there are heads of courts who opposed judicial case management. Heads of courts who said it's not a judge's job to get people along to agree and to get trial ready. There are judges who said their job is to hear matters. But we knew that these matters get packed in our processes and they don't move. We need to move them. That was one of the key resolutions of that retreat, Chief Justice. So I'm saying it's a thought that I thought I'll share with the Chief Justice to say the leadership of the judiciary in South Africa has evolved. We need to find each other as the leadership. We may benefit because in that one, Chief Justice Mogoeng had called judiciary leaders from other jurisdictions to come and sort of help us come to grips with our reality. I think the context may be ripe for us to have another retreat under yourself, Chief Justice, so that we find ourselves and we pull together. There are a lot of other things I can say, Chief Justice, but thank you for giving me this time to say this is what I see the Deputy Chief Justice role to be. Thank you very much.
Thank you, Judge President Lambo, for that strong statement. And just to round off quickly, for my part, I forgot to mention one important item of your CV, the fact that you have actually acted in the Constitutional Court previously.
I did, Chief Justice, for 8 months in 2022.
And you penned judgments for that court during that
I did.
stint.
I penned 2 judgments.
Yeah. And as you have already mentioned, you will be returning to the court to act in the 3rd and 4th terms of 2025, next month.
Yes.
And we look forward to welcoming you back.
Thank you very much.
Helping us with cotton line and all these newfangled technological measures that, that give us, some of us, trouble. I just wanted to mention that I've heard the suggestions you make for the Constitutional Court in particular, and happily, it's measures that we have already started to put in place. And there's one important one you mentioned, the ability of the court to hear matters, consider matters that come before it in smaller panels, which requires a constitutional amendment. And we have a very cooperative Minister of Justice who has listened to our plea to make sure that this constitutional amendment takes place in the very short term, because the court is drowning with work. And that project is already underway. So hopefully, within a relatively short time, the Constitutional Court will be able to function as efficiently as the Constitutional Court, the Supreme Court of Appeal does, hearing matters in smaller, panels and not having everything clogged up for 11 people to decide. But we accept the encouragement. Now, lastly, from me, for now, a niggling issue. You and I have worked together and supported each other in this institution for a long time. So I know your work style. And you have made it very clear in the presentation you just gave now about the role of the Deputy Chief Justice, that you understand that role to be to actually support the vision of the Chief Justice, as work is done to run the judiciary smoothly, efficiently, and in a way that conforms with the constitutional mandate that is conferred upon the courts. But I still have to ask you this question, because when I was interviewed for the position I hold now, it was asked by a representative of the Heads of Court cluster, of which you were part even then, whether South Africa is ready for a woman Chief Justice. And I want you to tell us, me in particular, in front of South Africa, whether having been a head of court for 14 years, calling the shots, having other people, listen to you, if you would struggle, it would pose difficulty for you to suddenly find yourself working under the leadership of a woman who is younger than yourself. I know the answer you're going to give, but I still want it on record.
Chief Justice, I will not have that problem. In fact, I don't think it's an issue at all. You will recall that when you were recommended as Deputy Chief Justice, in fact, starting as President of the SCA, we had a discussion, and I supported you. I said, it's time, and thanks for accepting the role. And when you are nominated for Deputy Chief Justice and appointed, I phoned you, I congratulated you. When you are appointed as Chief Justice, I said, we vied for this job together, you got it. Congratulations, you can rely on my support. And I want to believe I've lived up to that promise of supporting you, Chief Justice. I don't see myself struggling with towing the line. I want to put it that way. I'm not in the judiciary for positions, Chief Justice. I'm in the judiciary to ensure that the judiciary fulfills its constitutional mandate in whatever capacity I find myself in. And I would gladly support you and work under you and abide by your dictates and directions, Chief Justice. I want to assure you.
Thank you, JP. And indeed, you have supported me fully in all my leadership positions in the judiciary, and I appreciate it. Colleagues, I don't know if you want to take the tea adjournment now, and then we can continue with the interview a little later. 15 minutes? What time is it now? 11:12. We come back at 11:30.
JP, first of all, maybe I should just acknowledge in your presentation on your vision, you alluded to the fact that you have empowered a number of judges. I think I should just mention that I am one of those that you invited to act at the Labour Appeals Court shortly after you had been appointed as the judge president of that court. I don't know whether you remember, you may not remember, but I was one of those. So I thought I should just, in attesting to the fact that yes, you have empowered a number of females, I'm one of those. I just want to touch on something that you mentioned in your vision about referring matters about the Constitutional Court, remitting matters to the SCA, where the SCA had not previously dealt with the matter. I have absolutely no objection to that. It makes a lot of sense. I just want to hear your thoughts on this concern that I'm raising. And in raising the concern, maybe let me just allude to the fact that prior to the 17th constitutional amendment that ended up granting the Constitutional Court general jurisdiction, there was a consultation process. And during that consultation process, a number of bodies and a number of courts did caution that it could cause bottlenecks in the processes. And eventually the amendment was granted and the Constitutional Court was granted general jurisdiction, and the bottlenecks and the delays that had been anticipated did materialize. And some comments are to the effect that the amendment was done, but the concerns that had been raised were not taken into account before eventually amending and giving the Constitutional Court general jurisdiction. Now, you have stated that you would advise the Chief Justice and your colleagues at the Constitutional Court, if appointed, to remit some of the matters to the SCA, and alluded to the fact that it is a well-oiled, the SCA is a well-oiled machine and has no backlog. It's a compliment to the court, and I thank you for the compliment. But I must just also caution that, as you know, the general complaint from all the heads of courts is that the capacitation of the courts in terms of judicial appointments is inadequate. So in other words, every single court has an inadequate number of judges considering the workload of the court. So my caution would be, and I want your comment on it, would be to say before implementing that, could you please then ensure that the SCA is capacitated in terms of the number of judges, because that stance obviously will increase the workload of the court, which has always been increasing over the years because generally the workload in all the courts has been increasing. Your comment on that, please, JP.
Thank you very much, President Mademela, and thank you for your acknowledgement of whatever little role I've played in your career development. I remember when you were sitting with me and JP Japi in the LAC in KZN, we were minded to go in a different direction, and you persuaded us in your very first sitting to say, you guys are wrong. And we said, come with the draft, and the draft persuaded us we were wrong. So I thank you for reminding me of that aspect. President Molemela, you're correct. I think the capacitation of all the courts is an issue. We have the report from retired Deputy Chief Justice Museneke as heads of courts, which makes a certain recommendation about judicial capacitation. So, yes, I can understand your concern that we should not bedevil the Supreme Court to start developing a backlog when it starts receiving those matters. My overarching view is, President Molemela, it will not be me imposing a thought. I think this will be subject to discussion by the Chief Justice leading us to say whether she agrees with this way. Because right now, there's an amendment that's being mooted by the Chief Justice that's sitting with the executive, I think, in terms of introducing smaller panels. I've not seen the amendment or the draft amendment, but my understanding is that that amendment only deals with the Constitutional Court dealing with new apps in smaller panels. I don't know whether it translates to also hearing matters. So I see the CJ is shaking her head. So
No, I wasn't shaking my head. It does.
So, yes, I think the judicial capacitation is one of the issues the Chief Justice is pushing, that courts need to be properly capacitated to deal with the work that comes. And I don't think one will be reckless in adopting any measures that could render another court dysfunctional. You're correct, but it feeds into what I've said to judges in the High Court. During the apartheid years, when common law still reigned supreme, the divisions in their full courts created law. And that was where matters ended. When they went to the appellate division will simply refuse leave, which is what is happening in the US Supreme Court. The US Supreme Court only intervenes very sparingly, and it's only when there's a divergence in views coming from the federal appeal courts. But the appellate division would intervene if the case law coming out of the different divisions was contradicting each other. They would intervene. So I'm coming to the point that I've said to judges, why are they so quick to grant leave to the SCA and not grant leave to the full court of the division? because that way it enables a matter to be adequately dealt with at divisional level, so that once it's heard by a judge and then 3 judges, when it goes to the SCA has the benefit of those 2 judgments, and then it can decide whether it hears that matter or not. And I'm not sure that it's a matter that will be willy-nilly appealed from going forward from the SCA to the CC. But I'm happy to hear that you have no objection. You find that there's merit in my suggestion. And I think the CC has said so in a number of judgments. I mean, the Kamichel judgment is one where the CC remitted the matter back to the High Court because I think there had been an absolution from the instance order granted, if I'm not mistaken. So the CC said it's not a court that deals with factual disputes and stuff. It must go back to the High Court to be dealt with. But if it has to do with the development of the common law, I think the SCA is well placed, better placed to actually deal with that matter before it goes to the CC, if it goes there. Thank you, President.
Thank you, CJ. You are being interviewed at a very exciting time for the judiciary, considering that an assurance or a commitment has been given by the President of the Republic that the steps will unfold within 6 weeks to give the judiciary the institutional independence it has been seeking for the longest time. That is very exciting indeed. And what is well known is that the judiciary has been under-resourced for quite some time. And I do not imagine that the first thing that is going to happen once we have judicial independence is that we will all of a sudden have sufficient resources. Now, the judiciary has been fortunate enough in the sense that there have been bodies that have been willing to come to its assistance in as far as the challenges that it is facing regarding the resources. Now, my question to you is, if the judiciary is to accept financial contributions or donations from third parties, there would obviously have to be a policy that allows us to do so. If you were appointed as the DCJ and you were asked to develop that policy, what steps would you take in terms of ensuring that the process is transparent, in as far as everybody knowing that they may, if they so wish, contribute, and what the parameters are in terms of the acceptance of contributions from third parties? Please let me know if my question is not clear.
I understand the question,
Thank you.
President Mulemela.
Thank you, JP.
Thank you very much. I sit in the fortunate position that I and JP Toba Boyohlwati, JP of KZN, were tasked with the responsibility of providing a policy, I would say policy statement, I wouldn't say policy document, to the heads of courts about how to deal with donations from third parties. So we provided a document to the heads of courts. It's still under development, but the issue is we've got to be extra careful as a judiciary when we accept donations from the private sector. I mean, that's the underlying principle in the document that we developed, and I maintain that stance. We can't accept donations from people who are tainted, who may feature in our courts as litigants. So the first thing I would do is to make sure that serious caution is exercised, and the document needs to spell it out as to where are the funds coming from, and does that entity have any history in terms of whatever has gone wrong in this country, malfeasance, if I may use that word, and what are the parameters of how we accept, whether we accept money or we accept services. And let me give you an example. In Gauteng, we have the Phineas Mojapelo Continuing Education Center. It's a state-of-the-art training center. We asked for money, we didn't get it from the OCJ. So the GCB, or the Johannesburg Society of Advocates, understood our plight, and we set up a trust committee to say we have needs. But what we don't want you to give us money. And we don't want to hear any discussion about money, about amounts. All we'll tell you is we need a training center. Please assist us in developing that training center. We have a training center. We don't know how much it cost, and we don't want to know how much it cost. But we accepted that assistance because professional development of the judiciary is key to us continuing to do our work. 2, we've accepted other forms of assistance from the JSA. I mean, you could simplify it by saying, when I go to an advocate and say, come and act pro bono, I'm actually asking for assistance, right? So we felt that that was a clean way of accepting it. So I know I'm giving a roundabout answer to your question, but I'm saying, I'm just emphasizing the issue of caution. And you mentioned the other one, transparency. Were we to adopt a policy of that nature, we can't adopt it and hide it. We need to be transparent, right? People who are users of the court need to know that the judiciary has this policy. And if we've accepted help from wherever, that needs to be disclosed in our accounting documents that we publish, so that people who interact with the courts know the judiciary has accepted acceptance and that assistance has gone to doing that or that or that. I think that will be the very first and important task. Thank you, President Mulimela.
Thank you, JP, for that comprehensive response. Thank you, CJ.
Thank you, President. Minister, are you ready now?
Thank you very much, CJ. Good morning, JP Mlambo.
Good morning, Minister.
You alluded to quite a number of issues that relates to access to justice. And you reflected around where people are starting to say in our communities, perhaps the constitution is not working. And also, you articulated that this can be understood in the context of poverty, but also just in terms of the cost that is associated with access to justice. In your comment, you say perhaps what is important, and also another issue that I would link to that is where you talk about the attack on the judiciary. Because in 2 of those instances, you are reflecting on the need to engage civil society as part of making sure that they understand what needs to be done. Perhaps, if I may say, if we look at various areas where you'd find some of the attacks, they would not be necessarily even from civil society or ordinary South Africans. And I think it could be my wrong view, and you can correct me. You shied away from mentioning that it is from political parties that you find the attack to the judiciary at most of the time. And my question would say, in that working for ensuring that we could see access to justice increasing, but also addressing the issues, how do you see the interface between the judiciary and political parties in the country, and to ensure that we are able to find each other in a single system that is in the best interest of South Africa?
Thank you for that question, Minister. One straight answer would be that engagement that the Chief Justice led us to meet with the executive is what I think is necessary. I did shy away from mentioning political players in the criticism of the judiciary, but I want to believe that the judiciary is an arm of government. And in terms of building committee with other arms, it's necessary periodically for the leadership of these three arms to come together. And it is in that gathering that the judiciary may express whatever concerns it has coming from the political arena. Because once you raise it with the leadership of the executive, right, or with the leadership of parliament, the legislature, you expect that whatever concerns you've raised will translate there. And whatever concerns that are raised against the judiciary will be fed back to the judiciary. I think that's one sure way that I think I can mention that can deal with political players who may be unhappy and who may be found to be criticizing the judiciary unnecessarily. I mean, one example is, you will recall when the Al-Bashir judgment was handed down, such an engagement happened. The president of the country at the time and the Chief Justice, with their respective teams, met to discuss that fallout and to call caution, to say, look, South Africa has international obligations, and the court, when it's confronted with a case that says, force government to comply with its international obligations, you can't then have political heavyweights calling judges counter-revolutionaries. So I'm saying that's one aspect that one can use to diffuse these things at that level, because you can't expect the judiciary to respond to individual statements coming up. But that engagement and can go a long way into diffusing these situations. That would be my answer to you, Minister. Thank you.
Thank you very much, JP. Another area that came strongly in your presentation is the issue of, as you were outlining what you have done in terms of your work and your career. It's around the directives that you have issued in terms of managing the caseload. And you've acknowledged some of the challenges that leads, or some of the experiences that leads to, either in criminal or civil matters, where you find that people are not finding dates in time. Maybe perhaps just to understand, and this in several times and continues to be challenged and within your ambit, if you could take us through what has been the benefit of this process. There are those that believe that this process is likely to benefit those that have money or that are able to negotiate better. Those who have big law firms that can negotiate, and therefore ordinary South Africans might find themselves in the back foot and not being able to negotiate better in terms of those directives, and can find themselves not having justice in civil matters that they bring before the court.
I don't know if you want to answer that question, Judge President Mlambo, considering that the matter is sub judice.
There is the matter is being litigated,
Yes.
Minister. So I don't know whether you want me to answer it, Chief Justice. I can give a general response.
All I'm saying is that it's being litigated. I leave it in your hands to decide whether you want to address it or not.
It has been decided already.
Has it? We may be at cross purposes, but I thought she was talking about the matter that has attracted a number of applicants seeking to challenge the directive you issued not so long ago.
I think the nub of the minister's question relies on that, but I think she wants a general answer. What has been the benefit of directives? That's how I understood the question, unless I'm mistaken.
Just tread carefully there.
Thank you. Thank you, Chief Justice. Minister, one aspect that I think needs to be debated in a retreat of the leaders of the judiciary is the taking away of the power of heads of courts to issue directive to address local dynamics. As courts, we've got different dynamics. The Supreme Court Act had a provision that gave heads of courts that power. That power was taken away in the Superior Courts Act. And that power was just given to the CJ, but to issue directives regarding case management and whatever. Now, I think it's important because when you are a head of court, you are confronted by dynamics that apply to you only. You can't sit back and not do anything. You need to look at the process flow and with the objective of balancing, like you mentioned yourself. There are big law firms that were dominating the unopposed motion court when I took over. You find that there are 25 matters from one law firm in the judge's role. And you find that the small firms get pushed away, right? And then they had to wait long because the big players are actually dominating that space. Now, when the rules are silent, what do you do as a head of court? You need to balance the playing field, isn't it? So, whatever directive I have issued, Minister, is a directive that is informed by the reality on the ground, by the need to promote access to justice to all in an equal manner. So I think I can give you that general answer, Minister, to say that each directive were not issued recklessly. There was a well thought out position, and some of these directives are a product of divisional meetings where judges as a division meet and discuss, led by those committees that are leading in those work areas. So it's not like it's my decision alone, right? So maybe let me stop it there. Thank you very much, Minister.
Commissioner Tsipane, did you raise your hand?
No, thank you very much, CJ. Good morning, JP.
Good morning, Chair of Chairs.
I'm not chair of chairs, JP. JP, coming from outside the Constitutional Court, how would you establish credibility among colleagues who have longer tenure at the Apex Court, particularly in managing the internal judicial processes or disagreements?
Thank you for that question. I want to believe that there's an internal committee in the judiciary about collegiality and respect for each other. And I don't foresee any problem whatsoever in colleagues in the Constitutional Court taking up a position that you're not coming from here, therefore you can't lead us. I'm not sure if it would be any responsible position to be taken by a colleague. We are all judges and we are all coming with experience at what we've done as judges. But one thing that I need to mention is, Chairperson, I have written in diverse constitutional law issues, in case there's any doubt in anyone's mind of my judicial exposure to constitutional litigation. I have that. And that should be enough to allay anyone who wants to rely on the fact that I'm not from that court. I have written those judgments. A majority of them have been upheld by the same court, that we interpreted the Constitution correctly. So I want to think my experience coming from wherever I am stands me in good stead. And having acted there for 8 months, in one matter, I didn't command a majority. In one matter, I commanded a majority. There is in another matter where I was part of a dissenting panel. So I am sufficiently independently minded to be able to do my work in the Constitutional Court. And I don't think there would be any qualms about that. I hope I've understood and answered your question correctly.
No, thank you very much, JP. I think you have answered me to my satisfaction. And I must also indicate, JP, your dedication to social transformative justice is truly commendable. And you also outlined the important responsibilities of the Deputy Chief Justice, and amongst others, you emphasized his or her role in managing court affairs, supporting the CJ's vision, facilitating judicial cohesion, and driving transformative change within the judiciary. In relation to what you have alluded to earlier on, how would you then describe your leadership style as a number 2?
Thank you, Chair, for that question. As a number 2, it would be consultative. I would consult my leader whenever I have new ideas about anything. And I would consult my leader when I see some other development somewhere, and to understand what her take is and what she would want us to do to address that. That's one aspect. Consultative. Inclusivity, I've mentioned. I have an inclusive way of leadership that I take people along with me. I don't do things because it's Mlambo saying this, right? As well an enabling environment that I want to create around myself, that I want colleagues to have the confidence like they've done in the division. Whenever they have issues of any nature, personal or professional, they know they can simply walk into my office and we can talk and we can resolve. So I regard my role as an enabler. But the important part, and that goes back to the question the Chief Justice asked me. As a 2IC, you can't be a loose cannon. You need to understand there's a leader of the institution. Even though there may be instances where the Chief Justice will be away and the Deputy Chief Justice acts, it doesn't mean that that Deputy Chief Justice is at large to interfere with the program of the leader. It's a consultative role more than anything else that second in command has to be acute to and aligned to. I think that's how I would answer the question.
Thank you very much, JP. Thanks, CJ. I have no further question.
Thank you, Commissioner. Commissioner Jozitube?
Thank you, Chief Justice. JP, I just have two sort of broad lines of inquiry, not necessarily questions, but just to get your philosophy as the potential Deputy Chief Justice. And I was very pleased to hear in your presentation that you highlighted the problem of poverty and inequality that bedevils the creation of the new South Africa. Now, as the Deputy Chief Justice, how do you see the role of the Constitution in addressing the economic inequality in South Africa? There are many theories of what a Constitution does. One of them is that it's preservative. In other words, it preserves the rights that exist at the time of its adoption. The other is that it's transformative. It seeks to rupture the existing relations, particularly around property, which is a defining feature of wealth inequality. But it's a contentious topic about why do we have so much inequality and so much poverty despite an apparently progressive constitution? So that's the first area I would like your views on, about how do you think, as a Deputy Chief Justice, you will theorize the transformation of the economy through the lens of the Constitution?
Thank you very much, Commissioner Jozitube, for that question. I think in one of my previous speeches, I've confirmed the statement you make that we adopted what is called a progressive constitution that seeks to uplift the plight of people. I've got people who represent legal formations here, because one way in which the Constitution can be used is to target particular bottlenecks that are continuing to confine South African people to inequality and poverty, to identify those particular bottlenecks and then bring carefully crafted litigation for the court to grapple with and ensure that the Constitution is applied to deal with that bottleneck. Commissioner Jozitube, you know, the issue of Rule 46A has been raised by a number of judges as a problem, in the sense that that is the rule that is used by powerful players like the banks to further take away their property, especially their houses. One aspect of it that has been mentioned is the issue of substituted service. To say, in many instances that judges have come across, the first time a hard-pressed defaulting bondholder knows that his or her house is under threat is when the sheriff knocks at his or her door. There's something wrong. There's a misalignment somewhere. You should be the first to know that someone is taking action against you, and you should take up that opportunity to see how you can negotiate. But as a judiciary, I think we need to find a way of reforming these legal rules that form part of this conservative legal culture that we've built in South Africa, that dismantles that conservative legal culture and understands the plight of people to whom the Constitution applies. So I've identified that, but I go back to my initial answer. It is a very contentious area because the haves are always eager to litigate, and they have deep pockets in terms of litigating. But the people who may want to attack particular areas don't have the money to do that. Let me give you another example, and this relates to land. In the early years when I was still at Legal Aid South Africa, we dealt a lot with people who were given land but didn't know what to do with it. And I say that advisedly because those are the reports that we got in those gatherings. Now, land is a very important facet of a person's human dignity. This is my land. I can build on it, I can live on it. But if you come from a system that has relegated you to a non-entity, that has blocked you away from knowing how to use land, how to access finance, right? You will find the example you get on people getting RDP houses and selling them and going back to live in shacks. It's a deep societal problem. So that one doesn't answer your question, but I think the executive needs to be alive to these realities to ensure that in its programs, it factors in the enabling requirement in what they should do in assisting people come to terms and actually take the right action. Now, I mentioned the issue of identifying bottlenecks. We have a number of legal professional bodies, and I've said to them in my speeches to their AGMs, why don't you create a legal fund? And I give the example of Thurgood Marshall, Justice Thurgood Marshall in the US, when he was a lawyer of the NAACP. He realized the NAACP has no money, but there are a lot of social transformative cases that he wants to take that can be funded. And they allowed him to create a fund, a legal fund, which would fund this litigation. And he was successful. So I use that example, and I want to use it in answer to you partly to say we've got organizations in this country that can establish those funds and that can interact with societal formations or with communities. I chair Owesome, which is a grassroots access to justice level, and the needs for legal services is very big. So through those funds, I think critical areas like those you've mentioned can be funded from deep pockets to make sure that the Constitutional Court is actually challenged to develop the Constitution in the way the Constitution was conceived. Let me stop it there.
Yes, thank you. I mean, suppose primarily what judges do is to interpret the statutes or the common law or the Constitution, but in a given case. But that interpretation can hinder access to property by disadvantaged persons. But then the only way the judges can do that is to be conscious every time they interpret the Constitution what they're trying to do. In other words, are they trying to rupture the existing economic relationships? Or are they trying to preserve them even unconsciously? And that is where I think I always have a difficulty, is that you get a judgment that is worded in apparently neutral terms, but its impact is radical in preventing Black people from accessing property. Because at the time the case was argued, just no one thought about the implications, because everyone thought, let's apply the rules. But they have forgotten that those rules developed in a socio-economic context of marginalization. So I just want your view on that issue of that sort of intellectual awareness that the law operates in a social context, but that context is to be sort of broken by this new constitution.
That is a function of conscientizing the judiciary. One of the judges we have appointed in Gauteng is extremely radical. But if you listen...
I don't want to know the name.
But he's radical in a positive way.
Oh, I see.
Because he's challenging us, who've been there for 20 odd years, to say, you've been here, and this is how you've been interpreting the law. You've sold out. That's the language he's used.
What do you say to that when they say you sold out?
Well, selling out is too strong to put. But Commissioner Nkokaitobi, you know, we have educational problems where judges are exposed to training if they're going to sit as equality court judges. I want to think that training can be embedded deeply for judges to actually understand what is it that they are going to be dealing with on the equality law front, not just process. It goes deeper. So social awareness, you know, and equality awareness, the past will come. I mean, that judge that I mentioned said to me when I said, but you didn't put your name forward to be trained on equality court cases. He said, no, a white man won't tell me what apartheid did to me. That's a very profound answer. So I think we need to embed more of these training sessions that actually challenge us and actually enables new incomers to the bench to actually understand. Because generationally, maybe we have sold out in being conservative and in interpreting things in one way, right? So I think my answer is that there needs to be this continuing engagement. And, you know, when I interact with colleagues in the continent, because some of them are more conservative than us, I'm sure you're aware of that, and ask, but you guys, you unshackled yourself from colonialism years before we did, but we've advanced further than you. Why? You know? So it is this conservative legal culture that I mentioned that's shackling us. And once we admit it as a judiciary, then we are well on our way to interpreting the Constitution in the right direction.
And then just lastly, JP, on the issue that you've dealt with, I think you gave the judgment in the competition court, although it was about jurisdiction in the Group 5 case, where you were in the minority. Regrettably, you agreed with me, but you were in the minority, so it didn't really help my client. But there's something important about that, which is you're talking about a conservative legal culture. And competition law is a particular area where this conservative legal culture plays itself out, and where the Constitution is playing a catch-up game, and there is no infusement of constitutional values within the interpretation of that statute called the Competition Act of 1998. And I want to single this out because if you compare it, for instance, with labor law, the judges are quite happy to infuse labor law with constitutional values. Or you compare it with land law, they're quite happy to infuse land law with constitutional values. But they are extremely reluctant to infuse competition law with constitutional values. Can you just articulate that for us and explain what your approach will be to that particular statute? And I ask this deliberately because you've got experience in it. You've written a judgment on it. You've had the debates on both sides.
I think, let me repeat, it's the conservative legal culture. And before I answer that one, there's another one that you're not mentioning. It's the Standard Bank case. As a leadership of the bench, we realized that the big players with deep pockets were actually using the current legal processes to actually disable vulnerable people. Because Pretoria has jurisdiction in Soweto, they could issue process against a Soweto bondholder in Pretoria. For that person to go to Pretoria, he or she may need to catch 3 or 4 taxis to get to Pretoria. That's one. 2, we said, but this claim is in the jurisdiction of the magistrates court. Why not issue this thing in the Soweto Magistrates Court, where this litigant is located? And we issued a Rule 16 notice and invited people because we knew what we were trying to solve. But legal culture trumped us because the SCA said, no, you've got inherent jurisdiction. And inherent jurisdiction is an incident of the common law. It says the High Court has inherent jurisdiction. But we understand that. We've got inherent jurisdiction, but we say, despite that jurisdiction, let's understand the realities that we have now, that this inherent jurisdiction is leading to injustices. The SCA told us to get lost, and the Constitutional Court told us to get lost. So in Group 5, it's the same thing. Co-conspirators of Group 5 went and pleaded guilty and got fines on direct competition law issues. And Group 5 decided to say, no, the High Court has jurisdiction simply because they want to bypass the tribunal, which is the body that is properly capacitated to deal with competition law issues. I went out on a limb on my own because I believe that I was correct. And you can talk to the chairperson or the JP of the CAC now. The effect of the majority of the Group 5 decision is that the tribunal is now routinely bypassed. And I don't think it's an unintended consequence of how we decide these cases. But I think to actually interpret the jurisdiction of the High Court that strongly, to say you can actually give it jurisdiction in such a way that it makes inroads into the competition arrangements that give that jurisdiction to competition law bodies, it's a problem. Thank you very much.
Thank you, Chief Justice.
Follow up, CJ.
Thank you, JP.
And that was 3 questions, Commissioner Ngoito.
Three questions.
Commissioner Marubokhai.
Follow up, CJ, on that one. Good afternoon, JP.
Good afternoon, Prof.
I just want to pick up on the Group 5 discussion that you had with Commissioner Jozitube. I mean, I don't agree with the majority in that decision. I agree with your outlook because those competition law authorities are there to do a particular reason, and of course it will help the High Court to reduce the workload in the High Court. But there is a further argument that arises from the competition law cases that have been decided by the Constitutional Court. There is a view that, and this view it's quite surprising because there is general acceptance that the Constitutional Court can deal with the Labour Appeal Court's issues quite well. But there seems to be this view that the judges of the Constitutional Court do not have expertise in competition law matters. And because they do not have expertise in competition law matters, the final say in competition law matters must be the CAC, which last time I checked, it had a status of a high court. So it not have a status similar to that of the LSC. What is your view on that aspect?
There may be merit in saying the CAC should be the final arbiter, but it is a court that is subordinate to the Constitutional Court in terms of the current legal arrangements, the opening up of the jurisdiction of the Constitutional Court. I'm not sure how to deal with that because there's merit in saying tax law, competition law, you may need to be properly enabled as a bench to grapple with these matters and actually understand what is meant to be done in terms of this competition law legislation. It may be a function of further training, but I think one aspect is probably to embed competition law experience and expertise also in that court. I think it would be one way of addressing it. Similarly to tax, but maybe I caution myself. Labor law. The Constitutional Court has given very progressive judgments in terms of supporting the LAC, in terms of developing the LRA. So if the Constitutional Court is able to do that in the labor law field, what about this? But look, Prof, the newcomers that are on the bench now never had the benefit of practicing in these areas, like competition law. So maybe that's one of the issues. I don't know, but I hope I've answered your question. Thank you.
Thank you very much, JP. CJ, I had other questions. I'm not sure, should I wait my turn or should I just pose them?
I was going to call you next.
Oh, thank you. Thank you. JP, you, apart from your labor law expertise, some of us respect you for your international law and refugee law contributions. And I think the lawyers who are practicing in those areas of law will be much happy should you be given the opportunity to get this work. When we look at international law, the Constitutional Court has been heavily criticized in how it has dealt with cases that deal with international law in particular. For instance, when one looks at the Lannister case and the SADC tribunal case, where the court was criticized for not grappling or misunderstanding the methodology of international law. Should you be given a chance to be part of that court, what role, if any, can you play in order to assist in developing or assisting that court to develop the South African jurisprudence in as far as international law is concerned?
I'm happy you mentioned refugee law. You see, the Chief Justice wrote a judgment called Ashebo. I'm sure you know about it. I happen to sit in a full court where I penned a judgment. It's called the Lembore judgment. In social formations, those judgments are regarded as conservative. Why? Because for a long time, our law was, if you enter a foreign national as a law enforcement officer, say, you are illegal. You say, no, I want to apply for refugee status. The law said, don't touch that person. Don't arrest him, let him go. Ashebo arrested that. Says, no, no, no. We are relegating some critical legislative enactments that enable law enforcement agencies how to deal with these things. So, unfortunately, I'll be unpopular in saying there's a lot of idealism that goes into some of these judgments that come from our courts. And I call it misplaced idealism. I know I'll be criticized for saying this. We want to be everything to everyone. Judges in Uganda confronted me, say, you guys in South Africa, you're giving problems to us here in how you're interpreting international refugee law instruments. Because we've got a particular way in which we understand where international law is located. But you guys in South Africa, you simply say the Constitution, the Constitution, the Constitution. And that's the issue, isn't it? The Constitution is the supreme law of the land. But I can tell you as I sit here, I've read some of the judgments where properly reasoned international law judgments have been displaced by our courts to say constitutionally that judgment doesn't go far enough. Our constitution demands the following. So I think we need to take idealism out and understand how law internationally has been interpreted and to what purpose, and understand what the purpose is. And then when we sit, I mean, the issue that Ashebo grappled with was the court in an earlier judgment had said, if you arrest and detain an illegal foreigner for being illegal in the country and for being illegal for years in the country, you are interfering with the non-refoulement principle. Detention has nothing to do with non-refoulement. Maybe I shouldn't say that because there's a case that comes from the Western Cape that has said that. So maybe I'm disabling myself from sitting in that case because they've referred it to the Concord. But international law is clear. It's deportation that is at the center of the non-refoulement principle, not detention. So I know I'm going around the belt, but I'm just saying, as a judiciary in South Africa, and I think the role I think I'll play, if I have the honor of being appointed, is to actually carry colleagues along in understanding that I've been around. I've seen judgments of the European Court of Justice in terms of how it's interpreted refugee law instruments internationally, right? And to say, why should we very quickly find an international, a constitutional ground to disable international law that is specialist and applies to that particular area? That's the most I can say. Thank you.
No, thank you very much, JP. And I think it is something that really must be taken seriously because there's been a serious academic criticism of the Constitutional Court in international law. But my second question is more of what I think is a revolutionary act that you have done of allowing academics or giving academics an opportunity to be part of the bench through acting appointments. And not only that, but seeing them through, some of them, to actually being appointed as judges. My limited research, I'm not really sure, and I stand to be corrected. I'm not sure if there is any bar in preventing academics from acting as judges, not only in the High Court, but also the Supreme Court of Appeal and the Constitutional Court. Should you be appointed, what role are you going to play in ensuring that that sector of the legal space is actually, President Mulemela just said now that the Supreme Court of Appeal is short of judges. What role can you play? Are you still going to be on that trajectory of saying, but these are other people that you can actually tap into, and I've used them before, and they have delivered? What role are you going to play in that regard?
It's a function of engagement with colleagues, Prof. We have annual SAJ gatherings. The CJ knows, I've mentioned this to her before, to say, I'm happy that in recent times, I've seen more Constitutional Court justices attending these sessions. Because what SAJ has done is to rope in international judges to come and be part of that week. And they choose particular areas where they have expertise, just to broaden our scope as a South African judiciary. Because, I mean, in the past, the South African judiciary was quick to say, if you don't have any local authority, then go to the north, Canada or England or the US. So I want to believe that academics, they cast their net very wide in terms of what they do. The only thing you have to do as a judge is to recognize their expertise. I ask, this is your expertise. Can I put you there, or do you want to go into other areas? Especially if you want to become permanent in future. It's in your interest to have experience on a broad level. But academics bring that breadth. You see, their unchecked independence is very good in terms of saying to us, judges who are products of a conservative legal culture, that's not the only way you look at things. There is another way of looking at things. But in terms of academics acting in the, I'm sorry if I use the term academics, it may be viewed as derogatory, but I find a lot of value in them because nothing prevents me legally from appointing them. In the SCA, I think there's a legal prescript that's against that. The president can correct me if I'm wrong. I think that's why they've never been appointed there. But in the Concord, nothing prevents them being appointed to the Concord. We have good experience. The late Justice Yvonne Mohoro came from that rank, isn't it? And she's not the only one. So I think as a judiciary, we stand to benefit from harnessing all the skills and experience we can find around us to ensure that we develop good jurisprudence about these issues. Thank you.
Thank you very much, JP. And the reason I mentioned Supreme Court of Appeal and the Constitutional Court is those courts sit in panels. So whatever damage that it is thought that academics can do, really they will be reined in terms of the system. That's why I raised those particular courts. Thank you very much, CJ.
Commissioner Moiman.
Thank you, CJ. Good afternoon, President Number.
Good morning, Commissioner.
It's just one from my side, which emanate from the point you raised around capacitation of the judicial establishment, and you correctly made reference to the recommendation from Moseneke's team on the rationalization process. But there's an area that I want to tease JP on, particularly in relation to access to justice. I suspect your referral to Sowetan that has to travel, to use 4 taxis to get access to justice it's an area that was also of interest to me. The committee, the Moseneke committee, also make some concrete proposal on the rationalization, particularly the recommendation on the Eastern Cape, that the seat of the Eastern Cape Division be moved to Bisho, which is the capital of the province. I want to get a sense from you in terms of your view on that, because it is quite important, because the work is informed by the legacy of apartheid, because with both the interim constitution and the final constitution retained not only the seats of high courts in South Africa, but also of the TBVC countries, which meant that many of the communities in rural areas must travel long distance to get access to courts, and it's also expensive. So I just want to get a sense from you as to whether, as an aspirant DCJ, what's your take on that other aspect of the Musenegas team? I believe that as the judge president, you also made some recommendation in relation to Gauteng. What's your take on that? Thank you.
Let me say this, Commissioner, thanks for that question. I first confronted that reality when I was chairperson of Legal Aid South Africa, when I was going around visiting the justice centers we have there, right? In Grahamstown, it's called, I forget what the new name is, and forgive me. Makhanda, yeah, in Makhanda. And then going to Gqeberha, and then going to Bisho. King Williamstown, I don't know what the new, is there a new name for King Williamstown? Once. Thank you. So, I say, from an institutional point of view for Legal Aid South Africa, if you have a justice center that's servicing Mdantsane cases go to Bisho, but East London cases don't go to Bisho. They go elsewhere at that time. I said there's an anomaly here. But the division was Mdantsane is black, East London is white. That's why there's this differentiation. And when I tried to tease the issue, I think the late JP Sangoni was a JP at the time, to raise with him. He said, look, that's a hot potato, seriously hot potato. Now, I'm not from the area, and I say that up front, right? I think the people of the Eastern Cape needs to address this issue. You can't have Gauteng. I've got 2 seats, Johannesburg and Pretoria, and I've said we need to have local seats in Palm Ridge, and I've asked for a local seat in the West, because a lot more litigation that comes to Johannesburg comes from the west of Johannesburg, a lot more of it. Now, you recognize that access to justice demands location of justice services where the people are. That's the overriding principle. So, you're throwing a curveball at me by asking me what my take is. I think the recommendation is there. As a judiciary, we need to express our view. We still haven't wrapped our heads around it, especially being led by the judiciary in the Eastern Cape, about how to deal with this issue. Consultation has happened. Maybe it needs to happen more, because there are seriously involved self-interests that seek to preserve the situation as is. Now, I don't know if there's a space for self-interest in deciding where justice services should be. I think that's the general answer I will give you. I don't want to get embroiled into a seriously localized issue. Thank you.
Thank you, JP. Thank you, CJ.
Commissioner Matolo Jepu.
Thank you, CJ, and good day, JP.
Good day, Commissioner.
I think mine is, I want to hear your comment. It's a follow-up from what Advocate Ngogaitobi was asking you about. And you said there are people who are worried about the constitution that is not working for them. I just want to hear your comment to say, do you think the judiciary is doing enough to dismantle the Roman Dutch law? Because that's what people are complaining about. And if we have to do that, what do you think the role of the judiciary could be? Because the judgments that comes out of the courts are the ones that the public is complaining about.
I mean, my immediate question, thanks, Commissioner. My immediate answer is not enough of those cases are coming to the courts. Section 39(2) of the Constitution is clear. You say Roman Dutch law, that's common law. The Constitution says we must develop the common law in line with the Constitution. And if there's a common law principle that's inimical to the Constitution, we need to develop the common law, like the Constitutional Court has done in its early days in developing in the right direction. So my first answer is not enough of those cases are coming, but those that come, I've mentioned two. We are trapped in a conservative legal culture that has conscientized us to approach these things in a particular way. I think we need to get out of that. Then we'll see the development of the common law go more, probably in the constitutional direction. That's what I would say. We need to see a lot more of those cases. Not a lot of them are coming. And those that come, probably out of 10, maybe one goes the right way. The other 9 reinforce existing prescripts. I'm just saying this as a very general point. Yeah.
Thank you. My second question is on the modernizations of our court. And I'm quite pleased about how the project, how it's